Fast forward, you come out channel so I'll say a GH politics avenue. Podcasters are training because making headlines. And your gym na EDB a sumo a waxy and idiom ni ahombraximo onia me srow say young simo. Na yan was subscribe to the channel. Hit notification bell also. Share na afi afofron so ensa into me and kebi emame. Ya make sure on your catches away inside Eddie amame. Young simo. Chairman unto me. After say ye granting ni be no. Still, ugusu ewo police custody. Na ne lawyer Akuffo etimi ababonten aboboyin chiremu dintia amana basa amana abanesa. Na nisa mo kanyina ne se ni bill ni de obitimi aka say is serving as a punishment because ohwe case a ye me fancy courts two no and so ede e to no so no ni nyina nenka ohwea nenka eye gadam si hu nsensem ya nenka ombetimi aka bom desenka ombetimi awi bibia ho ba ankoba ne sa na emom de oka ne se omo entimi emitic be condition no enti assistance now de untumi any kwame entwi any Akonta mine company limited ni nyina omo nyina hu nsensem no ena ede abona onua baako sisia Wontumis angode fia me no ka say ogusu ewo police custody yembo enwura lawyer Akuffo ne nchen na abra wajemra oboyin chiremu ewo hasi AGH politics.
This is Akuffo earlier today. Take a look.
They are alleged to have committed and also making it difficult for them to be able to discharge their responsibility to secure the bail. It's a national issue that we need to discuss and not accept. It's becoming too many that accused persons are being subjected to a difficulty of finding value for properties that will secure their bail. It is a national issue that we need to discuss. I'm not sure that there's anything untoward, but there is a process that we need to accept and make sure that it serves the purpose for which the law was made. And in many cases,
so he also did indicate the position of the lawyers, that's the of Bernadette Chibuesiako about this 25 million cedis bail condition and the fact that he is certain that they will meet this condition by tomorrow. All things being equal. Take a look.
We've been able to secure bail for Wontumis and his company and the other accused person. They have been admitted to bail on various sums and justification. We are working on executing the bail conditions. We are currently working with the registrar of the court. Unfortunately, at this time, we are not able to secure the release of the accused persons for reason that the police will have to go and inspect their houses, the sureties, the houses of the sureties, and come back and give a report before the registrar could execute the bail bonds. So for now, bail granted in both cases. What I have to explain is that there is one case pending before Court 4, Criminal Court 4, and another pending before Criminal Court 1. We secured the bail and its associated conditions in the morning, only be slapped with another case that we needed to go to Court 1 to prosecute it. So the charge sheet as given to us was around 2 o'clock. So the court has just finished the second one and also granted bail.
So it's instructive to place the point of analysis here that Akuffo, the lead counsel for Chairman Wontumis, stated something that Dennis Wadam Esquire is going to get into, and we'll get on that path shortly. There are two cases today. There was a case at the Criminal Court 4, and then also another case at the Criminal Court 1. So initially, they had met the bail conditions for the case in the criminal court 4, that's 50 million. And then later, when the Sansa, another 10 million was slapped on him. That's the total of what we're seeing right now. And let's get a bit more into this. The full details of these two cases and the charges that are contained in these two cases that were heard in the criminal court 4 and the criminal court 1 earlier today. Dennis Pabere Wadame Esquire is with me. It's good to have you, as always.
Always a pleasure, Alfred, being here.
You're an officer of the court, so I know earlier today you kept an eye on what was happening in this particular case.
Precisely so.
Let's get into it. What happened?
Yes, so we all were looking forward to what was going to happen today because the Attorney General had given us heads up as to what exactly was going to happen, except we didn't know the kind of charges that were going to be leveled against Chairman Wontumis and his 4Akonta mining company. We didn't also know who the other persons were going to be, even though he had mentioned that in his own words, Chairman Wontumis and 5 others.
Right.
It did appear that the case now became cases because now there are 2 separate cases, both bordering on illegal mining. But the cases are founded on different or distinct set of facts.
Right.
And that's why it's important for us to separate the matters. The first one, like you rightly indicated, was the one that was brought against Chairman Wontumis and 2 other persons. The other 2 persons included the Kwame Entry and then 4Akonta Mining Company Limited, which is the company that he owns. Later, we'll get to understand who exactly the accused persons are, because there's a portion that we'll dedicate to knowing exactly who they are and what their state of being is as we speak. So in that particular matter, the counts largely were in respect of assigning of mineral rights without approval from the minister, assignment of mineral, the same thing against Kwame Entry. Then,
and when this Kwame Entry is at large?
He's at large, yes. What it means is that
he cannot be found.
They don't know where he is at the moment. There's also a corporate liability for unauthorized assignment. That is count 3. Count 4 also talks about purposely facilitating unlicensed mining contrary to the mining laws. Count 5, purposely facilitating unlicensed in respect of Kwame Entry. And then the last one has to do with corporate facilitation of unlicensed mining. Now, Alfred, if we go into the facts on which these charges are grounded, then we begin to appreciate how this is distinguished from the other case that we look at, which is Chairman Wontumis and 4 others. In that one, we have 5 accused persons, unlike the first one where we have 3 accused persons. Now, this is how we have summarized the brief facts. So the brief facts usually will tell you what exactly happened for which prosecution is bringing charges against these people. Now, they talk about a police operation, which took place somewhere April 16, 17, 2025. It was an anti-galamsey operation somewhere in Summerboy that the police arrested 29 persons, including one Michael Jedu. They recovered some items, including cash, gold, and 29 excavators.
I see.
This happened, take note of the dates, April 16, 17, 2025. So we are talking about this year.
True.
Now, this Michael, who was among the persons who were arrested, named one Henry Okum as his employer. Now, Mr. Okum admitted under caution that he obtained direct permission from Wontumis in September 2024 to conduct mining activities within the concession. Follow the trend. 29 people were arrested, including one Michael. That Michael names a Henry to be the person who employs him. Now, the Henry person also admits that he obtained the direct permission of Wontumis to mine in that particular concession.
In September 2024?
That was September 2024. But the operation was carried out in April 2025.
Okay.
Now, investigations, according to prosecution, established that Wontumis authorized the said Henry Okum to mine within 4Akonta Mining's concession without legally required approval from the minister. So it is the case that if somebody must mine in your concession, there is a procedure that has to be followed. It is the view of the prosecution that that procedure was not followed. So Wontumis did not follow the right process to give this Henry person that authorization for which he too could employ another person to go and mine in that concession.
Who gives authorization to go mine?
The minister.
It's the minister for lands and natural resources.
Yes.
He signs the licenses.
Exactly.
And not Chairman Wontumis in that sense.
So that is the basis for this particular charge. So, briefly, that is what formed the basis for the charges that we saw earlier in respect of these 3 persons. Now, let's look at what the second case has to do with. The second case against 5 persons. So this time around, we are flipping it. We are looking at the brief facts before we look at what the charges really are.
Perfect.
Now, this case is coming from multiple petitions that were lodged with the CID against Akonta Mining and Chairman Wontumis for unauthorized mining activities within the Tano Nimri Forest Reserve. Multiple petitions, and you do recall, under the previous administration, there were quite a number of petitions.
True.
And we know names of persons who have petitioned the CID then to investigate Chairman Wontumis and Akonta Mining.
But the former president was clear that at the time he was speaking, just around the same time these petitions were filed, that Akonta Mining was not involved in illegal mining.
Yes.
You recall that?
However, this narration will point to something else. Now, that police investigations reveal that while Akonta Mining lawfully obtained mining leases in the said area, Samurai Boy and Abekwasi in July 2022, its application to mine in the Tano Nimri Forest Reserve was refused. Right. So yes, they had mining, they had obtained the mining leases in the said area. However, when they applied for the license to mine in the Tano Nimri Forest, that was refused. That the company deployed over 40 excavators, erected unauthorized structures, and carried out extensive mining, causing severe environmental destruction, including devastation of 13 hectares and pollution of the Tano River. Mind you, they said they did not have the permit to go into the forest reserve.
Absolutely.
But this is what prosecution says has been the destruction that they caused as a result of going in there without a permit. Now, when Forestry Commission officials seized some equipment, Akonta Mining Company's armed personnel, led by its managers, forcibly retrieved them. So this is the basis for the second set of charges. These are in respect of matters that happened before this particular administration, because these were petitions, the investigations were done somewhere in 2022, and it also ties into the comment we heard from the Attorney General to the effect that a docket was prepared along the line, they could not find the docket, he was brought to him, which he signed off, and this is it. Now, let's look at the key players in this. Who are the accused persons? In all, there are 5 persons, 1 artificial person, 4 natural persons. Akonta Mining itself. What prosecution is telling us is that this is a company which is incorporated under the laws of Ghana. It was incorporated on November 5, 2010. The object was for mining and exploration. The second person is Chairman Wontumis himself, Benadenchi, a 40-year-old man, entrepreneur, and one of the 2 shareholders of the 2 directors of Akonta Mining. Let me explain.
Right.
So Akonta Mining, as incorporated, had 2 shareholders. Chairman Wontumis was one of them.
Right.
It had 2 directors. Chairman Wontumis was one of them, or is one of them, as it will show in the record of the Register of Companies. Now, Kwame Yenchi, who is said to be at large, is also listed to be the other shareholder. So he's a co-shareholder and also a co-director. So he and Chairman Wontumis are shareholders and directors.
You recall that
at least that's what prosecution says per the record that they have from the Register of Companies.
Yeah, and one of the demands of this, one of the petitions to the CID against Chairman Wontumis or the Akonta Mining by, as we'll see later, Edemson Anu, Law.Kpebu, Engineer Kenashigbe, the 4 of them.
Yes.
They were demanding the identities of the directors and the shareholders of Akonta Mining. So now we know.
Exactly. It gets more interesting as we go forward. Now, in respect of this person, prosecution tells us that when they asked Chairman Wontumis to know who this person is, he indicated that after having signed off all the documentation for the incorporation of the company in 2010, he has no idea where this person is.
I see.
Prosecution did indicate that they are still carrying on investigation to see if this person still exists, because there's a suspicion that this person may not actually exist.
The Kwame entry person,
yes,
who is at large.
That's why they say it's at large.
They say
because the co-shareholder, co-director does not know where he is. He says since 2010, when they incorporated the company.
He says he doesn't know where
this man is. Yes,
co-director.
So prosecution has suspicion that this person may not actually exist.
Okay.
Edward Ekwaku, he's the general manager of Akonta Mining Company Limited. He's 48 years. And then Kwejo Owusu Bempa, alias Sly, he is operations manager of Akonta Mining. So you recall that they said when the Forestry Commission people went in to see some equipment, that the company's armed personnel came with managers of the company.
Sure.
These were the two persons that they were talking about. So based on this, they preferred the charges, which included undertaking mining operations without license. They also went on to prefer the charge of felling trees in forest reserves without written authority from a competent forest authority, abating the unauthorized felling of trees in a forest reserve, and also erecting buildings in forest reserve without written authority. So in respect of this, these are the charges that have been leveled against them. So the clear distinction between the two cases is that one has to do with facts that preceded this particular administration,
yes,
and the other one has to do with facts that are within this particular administration. So that's how you can simplify the two particular matters. In respect of one, 15 million CDs bill, 3 sureties, 2 of which was to be justified. In the other one, 10 million, 2 sureties.
Yeah. Let's stay the steam on this one. This one that bothers on the petitions received by the CID prior to this administration, right from 2022, a number of petitions against Chairman Wontumis. In fact, Akonta Mining's operations in some forest reserves. One of the petitioners is joining us on Zoom right now because one of the petitions against Akonta Mining was the one that was sent to the CID by Law.Kpebu, also Adam Senanu, and then we have Engineer Dr. Kenashibe. They were all part of the petitioners of one of these petitions we're talking about against Akonta Mining. Law.Kpebu is going to be joining us shortly on this same matter, but Senanu as well is a co-chair of the Citizens Movement Against Corruption, one of the petitioners in this one of the petitions in the Akonta Mining at the CID is joining us right now. Thank you, Senanu, for joining us here on Ghana Tonight. Senanu, if you can hear us, would rectify the connection to Adam Senanu shortly. But let me also then acknowledge the presence of Law.Kpebu. He is a private legal practitioner, one of the petitioners as well. Dennis, we have them, right?
Yes.
And this was in 2022, right?
2022, yes.
Okay. Who are these?
So Dr. Kenashibe, founder of the Media Coalition Against Galamsey, then now Ghana Coalition Against Galamsey. Now Law.Kpebu, legal practitioner, Adam Senano, co-chair of the Citizens Movement Against Corruption, and Kwame Esedu, fellow at the Center for Democratic Development, that's CDD Ghana. So these were the 4 persons who petitioned the CID in 2022 for the CID to look into the operations of Akonta Mining and also to look into the conduct of Chairman Wontumis himself.
See, let's backtrack a bit. And thank you so much, Law.Kpebu, for joining us here on Ghana Tonight. You just saw your face there. But then again, let us start off with the concern raised by Chairman Wontumis' lead counsel, Andy Apiakubi, that this bill sum of 25 million, in his view, is frustrating, and that, as he's saying now, the bail conditions are being used as some form of punishment for accused persons. You are passionate about bail. Your contribution to jurisprudence in the matters of bail is clear and documented. Will this concern find favor in your sight?
On this particular one, I'm able to stick out my neck to say it is excessive or not, because I don't have the full facts. When I mentioned I don't have the full facts, what I'm looking at here is the cost of reclaiming the land. You see, he is alleged to have committed galamsey, right? And we all know from even some of the complaints that we even laid earlier. You know, we even sent a petition to the CID earlier in 2022, etc. What you are looking at is the distraction to the forest, distraction to the environment. How much would it cost to reclaim? So in a case like this, it will be fair to look at that. And so that would influence the amount of bail being set or to be set. So because I don't know how much it will cost to reclaim the land, it's not easy for me to say this is harsh or this is lenient. Yes.
I see.
Because let's give an analogy. You see, so let's say if 100 million Ghana cedis was lost, stolen, etc. Normally you hear the judge say, okay, post bail in the sum of 100 million cedis, because if the facts show clearly, I'm not saying every mention of any amount, then the judge will put the same amount as bail. No, you look at the facts. If you can show that 100 million cedis left one person's hands and entered another person's hands, and they have since not left that second person who is being accused in court, yes, it would start to reason that the judge can say, okay, post 100 million cedis bail. But let's say if that same 100 million cedis were to come into the hands of the accused, and then the evidence shows that, oh, the accused used part of the 100 million cedis to buy land, houses, cars, and then the facts of the case show that, oh, they have impounded, the police have impounded, of course, then there are issues of go for freezing. So for now, I'm just using the word impounded loosely. But what I'm saying is that if the facts show that, oh, they've taken charge of the houses, the land, etc., and you can see, even if they don't put values by each one, but let's say if they say out of the 100 million cedis, we saw that 100 million is not even up to $10 million. Yeah. But let's say, let's just round it up. So if they say, oh, we got, let's say, 5 plots of land in East Legon, maybe Range Rover worth 200,000, Land Cruiser worth $150,000, or even if they don't say $150,000, but they say 2024 model of a Land Cruiser, Range Rover 2023. You see, as soon as they mention a number of things, even without an official valuation, we all have an idea that, oh, a fresh Land Cruiser would cost this, a fresh, you know. So in such a case, a judge may put the bail at, let's say, 20 million Ghana cedis, even though he's alleged to have stolen 100, because in that case, you see that a lot of property has been impounded or frozen. And when I say frozen, sometimes there's no official order yet, but at least what the police are saying is that they have taken over. And I'm saying in such a case, the figure will come down. So it's always about the facts. That's why I said for me, in this Wontumis case, the critical thing I'll be looking at if I were a judge in setting the bail would be the cost of reclamation. Yes. So in that case, we would wait to get a fuller rendition of the facts to be able to make a determination whether we think that is harsh or unjust.
I see. But you listened to Dennis and he ran through all the charges that have been preferred against Chairman Wontumis. He denies all these accusations. He says he's not guilty. The burden of proof is heavier on the state or the Attorney General, for that matter, to prove this, is it not? And so, in the words of his lawyers, to the extent that bail cannot and should not be used as a form of punishment or be excessive, you are looking at it from the perspective of the alleged crimes. You juxtapose that against the amount that has been slapped. Will that suffice?
Yes. Yes, I'm looking at what is lost. Yes, it's standard that a judge in fixing bail will be looking at what has been lost. You see, so Wontumis lawyer cannot just throw it in the air that it's excessive. What you are looking at is what's been damaged. What have we lost? What has been damaged? What have we lost? These are the things. Yes, as for not using bail as punishment, yes, that is law. You are looking at section 96, subsection 5. No, actually 4. Maybe I can read it. It's law. I have it here. It says, a court shall not withhold or withdraw bail merely as a punishment. merely as a punishment. Yes, that is the law. But as I've mentioned, in this case, let's look at the facts. If you are looking at the a license from one company to the other without authorization, all those things, the most tangible one is the distractions. You see, the actual harm in the forest. Those are the ones that you can use to quantify. The other ones are smaller. They are generally minimal, of course. You see, so let's get all the full facts. But let's also remember that when Wontumis went to Iyoko, I think the bail sum was bigger than this. He satisfied it. Yes, let's check the record. At least the last time we knew, in Iyoko, the bail sum was not less than 100 million. Yeah, it wasn't less than. You remember that's the one, even the political, the candidates in his party were, falling over themselves to try to help him meet the bail conditions so that they can use that as part of their campaign message to the delegates. But I know that figure was bigger than this, it would appear. Yes, but he met it. So it means that this one is a matter of time. But let me quickly add that, you see, as we talk about this bail, trying to meet the bail conditions, one part we need to modernize ASAP is the searches. If you're bringing land, you see that when you go to Lands Commissioner, you want to conduct a search. It's not easy to get a search within a day or two unless you end up paying bribe. The system has not been fixed to give you a search within 2 days if you don't pay anything to induce the system. It's terrible. So I like mentioning it in court to judges that the moment we mention justification, then it means that we are just generally entrenching corruption in the public sector. Ask any lawyer, standard. You are going to conduct a search, you need it quickly for the accused person to come. If you pay just the official fee, forget it. The accused will rot in the custody for more than a month and you will not be done. So in our bid to get the accused person out quickly, you have to, do something over and above the official fee. So much so that it becomes standard that, look, the official fee alone to the Lands Commission will not get you anywhere. We can't build a system like that. So please, we're begging the authorities to look at how to modernize the system for conducting searches at the Lands Commission and other government agencies so that it can weed out this rent-seeking corruption that we are entrenching.
And it's a progressive recommendation. I appreciate you. Thank you. Law.Kpebu, private legal practitioner. Let's stay a bit further on this. Dennis did reference the petitions which form the second part or the facts of the second case that was brought against Chairman Wontumis in the Criminal Court 1, as we got to know today. These were the petitions that were sent to the CID as far back as 2022 about some allegations of this Akonta mining being involved in illegal mining in the Tanon Forest and other areas. One of the petitioners, Law.Kpebu is one of them, but another petitioner is joining us, Adam Senanu, the co-chair of the Citizens Movement Against Corruption. Senanu, thank you very much. And getting to know that today that the petition you sent in 2022 formed part of the facts for one of the cases brought against Chairman Wontumis earlier today, plus the fact that the Attorney General did indicate the missing docket on this case had been retrieved and returned to him. Does all of this inspire any confidence?
The initial petition, I remember, was in 2022, and it was on the Tano Forest Reserve, if I am right. We do not appear to have had traction on that case. And so this is a new case. I hear it's based on the forest in Samre Boy. And whilst it is used
we and some who team because or channel so mamma was so jemre or had a sense of body in the Dominion. Only a percent room near some question aha a GH Politics Avenue.